Hello, my name is David Winch. I'm a forensic accountant with Bartfield's Forensic Accountants. And in this webinar today, we're going to spend a few minutes looking at some recent case law of interest, some in relation to confiscation and some in relation to expert witnesses more generally. So let's have a look at the agenda. We'll start with a Court of Appeal case, the case of Berkani, in which the Court of Appeal discussed the role of expert witnesses and a few other things which aren't particularly of interest to us. So we're just going to concentrate on the expert witness bits. And then we'll talk about the expert witness in a confiscation hearing or in a forfeiture hearing and how that might be a little bit different from an expert witness in a trial in front of a jury. Then we'll catch up on some case law of some recent confiscation cases and round off, as we always do, with a few words about how Bartfield's Forensic Accountants can help you. Okay, so let's kick off with the case of Berkani. It is a recent case. It was May of this year, involving expert evidence. It wasn't a proceeds of crime case. It was in fact a case involving a conspiracy to supply cocaine, involving an organized criminal group, OCG. But in this particular case, the defendant, Mr. Berkani, was saying that he was a victim of modern slavery, and that was his defense. So if he could show that, if he could satisfy the court that he'd only acted as a member of the conspiracy because he was acting as a victim of modern slavery, then he would have a good defense against the charge. In his particular case, there's a body called the Single Competent Authority, which is part of the Government Home Office. And that body had previously concluded that Mr. Berkani was a victim of modern slavery. So you might think, right, job done. He's a victim of modern slavery. He's got a defense. He's going to be acquitted. Well, it didn't quite work out like that, as we shall see. There were two expert evidence issues which went to the Court of Appeal. The first was the decision of the Single Competent Authority admissible at his trial as expert evidence? And the second was some evidence contained in two long reports from a person who described himself as an independent forensic social worker and criminologist, were those reports and was that person's evidence admissible as expert evidence? Ultimately, the Court of Appeal answered both those questions no. And that came as a little bit of a surprise, because in previous cases, it had been thought that if you'd got a favourable decision from the Single Competent Authority, you were home and dry as far as a modern slavery defence was concerned. Berkani establishes that is not the case. But our interest, of course, is particularly in the expert evidence side of things. The court, in its judgment, went into some detail into Rule 19.4 of the Criminal Procedure Rules, and that's the one that relates to the content of an expert's report, and it lists various elements which should be in the report of an expert witness in criminal proceedings. It also quoted the practice direction which accompanies Part 19 of the Criminal Procedure Rules, and that practice direction refers to a previous case with a fairly unpronounceable name of something like Dugoz. Sorry to him if I've pronounced his name horribly wrong. And what the Court of Appeal said was that the decision of the Single Competent Authority was opinion evidence. It was an opinion from the authority that this particular individual had been subject to modern slavery. But it was opinion evidence which did not satisfy the requirements of the criminal procedure rules. And the Court of Appeal went on to say that the independent expert witness who gave evidence had relied very heavily on assertions by the defendant which were uncorroborated and, as they put it, without consideration of core relevant information, including information from the defendant's phone. The background to that is that the defendant's phone had on it texts and emails and so on, and photographs showing him apparently having quite a pleasant time and in a relaxed demeanor. And it was said that those photos and video and what have you were not consistent with the defendant's assertions that he was acting against his will. He seemed to be having a jolly time. And the independent expert witness had relied on interviews with the defendant, both interviews that that witness had had himself and interviews that others had had with him as to his mental state and so on, but apparently hadn't been provided with this information from the phone, and therefore had come to his conclusion based, the Court of Appeal considered, on misleading factual information that the expert had been given. Well, if the expert's basing his decision on misleading factual information, then his opinion isn't worth very much. And the Court of Appeal said that the Crown Court judge had been correct to exclude that evidence from going in front of the jury, and to exclude from going in front of the jury the evidence that the single competent authority had reached the conclusion that it did. The judgment includes quite, I'm going to give you quite a lengthy quote, and it is a quote from a previous Court of Appeal hearing many years ago. And it says this: "The opinion of scientific men upon proven facts may be given by men of science within their own science." And pausing there, one of the points that we're very familiar with as experts is that we give evidence within the area of our expertise. We do not give evidence outside the area of our expertise because we are no better placed than anybody else to give evidence on that. So that's what that part of that quote is hinting at. Proven facts may be given by men of science within their own science. An expert's opinion is admissible to furnish the court with scientific information which is likely to be outside the experience and knowledge of a judge or jury. And that again is another key element. Information which is likely to be outside the experience of the knowledge of a judge or jury, so that they could not themselves, without the help of the expert, deal properly with that evidence. If on the proven facts a judge or jury can form their own conclusions without help, then the opinion of the expert is unnecessary. The fact that an expert has impressive scientific qualifications does not, by that fact alone, make his opinion on matters of human nature and behaviour within the limits of normality any more helpful than that of jurors themselves. And I think I should stress that. His opinion on matters of human nature and behaviour within the limits of normality. So his opinion on those ordinary things is not going to be any more helpful than that of the jurors themselves. But there is a danger that they may think it does, presumably because he has impressive qualifications and so on. So what Bacani is saying here is that you do not get in front of a jury an expert to pontificate on things that are outside of his expertise, or on things that the jury can deal with perfectly well themselves without needing expert assistance. And we will come back to those sort of ideas in a few minutes. In my experience, individual judges differ in how far they will let an expert give evidence on the inferences to be drawn from the facts in evidence. So that I have found, for example, that as an expert witness, I have been drawing together information from different places within the evidence in front of a jury, comparing one piece of evidence to another to see if they corroborate and support each other, or in fact, if they appear to conflict. But I have had the judge not wanting me to say, these conflict. Just wanting me to say, right, here's the evidence, we can match this with that and see how they look together, and stop there. Now, another judge on another day might be perfectly happy for me to carry on and say, the inference we can draw from this is that these two are not actually related. They are not examples of cause and effect, or they're not connected. Depends on the judge. As an expert witness myself, I may be naturally more inclined to place more importance on expert evidence in a trial than perhaps the judge would. Obviously, I have to resist the temptation to try and regard my expert evidence as the single most important piece of evidence in the trial, because actually the most important evidence is likely to be from witnesses of fact who have actually seen what happened. And if the defendant himself or herself gives evidence, then that again is likely to be extremely important evidence. But what about confiscations? Now, arguably in confiscations and in cash forfeiture proceedings, where there is no jury, the court can be more relaxed about the admission of evidence. Because let's face it, the judge or the magistrates are very experienced in hearing evidence. They hopefully understand the law, and they are able to exclude from their own minds anything which is not relevant or which shouldn't come from the expert. So hopefully they can sift it in a legal sense, with legal knowledge and with experience of court proceedings, in a way that might be too much to ask for a jury. In confiscations, the Crown puts forward a Section 16 statement, which we're all familiar with, or in a forfeiture application, it will put forward an application, and that will be written by possibly a financial investigator who is not, emphatically not, acting as an expert. Because he's not an expert, because for one thing, he's not independent of the prosecution, he's a member of the prosecution team. And an expert witness is required to be independent and unbiased. The author of the Section 16 statement, or the author of the forfeiture application in a cash forfeiture application, or a bank balance forfeiture application in front of magistrates, is not required to be independent and unbiased. So this is a statement which is written by a non-expert who will nevertheless give opinions in evidence and make assertions as to the legal position. How does that leave the expert? Well, the confiscation legislation refers to statements of information. And importantly, it uses that expression, statement of information. It doesn't talk about a requirement that the author of the Section 16 statement should give evidence. It talks about him giving a statement of information. And arguably that broadens the scope of what may properly be included. Perhaps it would be appropriate, I think, to consider these witnesses not as experts, but as skilled witnesses, pulling together data, factual information, and making some sense of it. So that that would be perhaps a better way of looking at it in terms of confiscations and forfeiture applications which are not in front of a jury. And perhaps the same should be said of an expert instructed by the defence, that possibly they should be given more scope to put information forward as skilled witnesses. Okay, let's talk about some recent confiscation cases. There has been some interesting past case law over the last year or so, and I just want to run through a selection of these. Obviously, your own selection of interesting confiscation cases or proceeds of crime cases from the past 12 months or so might be different from mine. And this is by no means, I'm by no means claiming to cover every case of interest over the past 12 or 18 months. A couple of cases on Section 10A determinations. You remember Section 10A determinations are where a defendant has or is believed to have an interest in an asset, and there is or there may be other persons who also have an interest in that asset, and the court has to make has to form a view on what the defendant's interest is. Does the defendant actually own beneficially 100% of the house in which he lives? Does he own 50%? And is the other 50% perhaps owned by his wife or girlfriend or whatever? One way of dealing with this is for the court to make a formal determination under Section 10A of the Proceeds of Crime Act. And that is a formal determination of the defendant's interest in the asset. And of course, in effect, that is also a determination of the other person's interest in the asset, because they will have what's left. What the cases of Hilton and Bevan confirmed is that the court can decide the defendant's interest in an asset without the formality of making a Section 10A determination. And in fact, it will often do so. Before Section 10A had been introduced, the courts dealt with these sort of questions routinely, and they still can deal with them in exactly the same way as they used to do, by just reaching a view and saying, right, we think the defendant has a 50% or a 75% or whatever it is, 100% interest in the property. And they can do that. When they do that, they don't make a formal determination under Section 10A. They can do it without doing that. If they do decide to go and make a formal Section 10A determination, then there is a procedure that they must follow. So if they're making a Section 10A determination, they have to allow third parties who may have an interest in that asset to appear if they wish to be represented if they wish to in the confiscation proceedings. But if the court is simply making a decision without making a formal 10A determination, then it does not have to offer an opportunity to third parties to be legally represented in the confiscation proceedings. So that where, in the case of Hilton, a challenge was made to a court's decision on the basis that the third party hadn't been allowed an opportunity to be represented, that challenge failed because the court had made its decision without making a formal Section 10A determination. Okay, Collins versus the DPP. That was slightly interesting, surprising decision by the Court of Appeal. I think what was surprising about it, perhaps to me anyway, was that the question was even asked, because it hadn't occurred to me to ask the question which was asked by the defendant in the Collins case. Effectively, what was said here by the defendant was, hey, several of us have jointly obtained benefit we are said to have hidden assets, which are presumably the same hidden assets from that jointly obtained benefit. A co-defendant of mine, we've all been given default sentences of similar terms because we have this huge alleged hidden asset. One of the defendants has served a default sentence. Shouldn't that have the effect of reducing the default sentence to be served by other defendants? So in effect, if let's say, to make it easy figures, that the default sentence is 9 years and there's 3 defendants, isn't that really a joint and several default sentence that the 3 defendants between them have got to serve 9 years? In effect, it might be 3 years each, or it might be 9 for one and none for any of the others. Isn't that, the argument went, how the default sentence regime should work in a case of jointly obtained benefit? Perhaps not surprisingly, Court of Appeal said no. Where the default sentence is served by one convicted co-defendant, that did not have the effect of reducing the default sentence to be served by another. They drew a distinction between the enforcement of available amount, where we know that the Crown cannot recover more than the total of jointly obtained benefit, where there are multiple defendants having the same jointly obtained benefit. But Court of Appeal said that's not the same thing as what happens with default sentences. A default sentence is for an individual defendant, and it's unaffected by what other defendants serve in terms of default sentence. Lowther and others, and the others were also called Lowther, decided actually a very simple point, but one that comes up from time to time, and it's worth knowing. And that's this: where a person's benefit and their available amount includes, say, a property that is going to be sold. So it might be that the defendant has a criminal lifestyle, he owns a property, the property in terms of benefit is assumed benefit under the Section 10 assumptions as property held after the date of conviction. It's also going to be part of his available amount because it's available to be sold. So the same property appears both in benefit and available amount. What about the costs of sale? Because if that property is going to be sold, there will be estate agents' fees, there will be solicitors' fees, and so on. So the amount realised is likely to be less, excuse me, less than the total open market value. Well, what the Court of Appeal said was this, excuse me. That's better. What the Court of Appeal said was this: the anticipated costs of sale, the estate agents, the legal fees, for example, are to be deducted in arriving at the defendant's available amount, but are not to be deducted in arriving at his benefit. The reason is that his benefit is what he obtains, and he has obtained the property. But the available amount is what he can actually realise, and what he can realise is going to be net of estate agents' fees and legal fees. I don't believe, by the way, that the same can be said of capital gains tax liabilities that might arise on the sale. I would not think that they can be deducted from either the benefit or the available amount. Okay. Zuman and Khan. Zuman and Khan was a complicated case involving very large confiscation orders, multi-million pound confiscation orders being made against Mr. Zuman and against Mr. Khan following their convictions for mortgage frauds. Now, one of the things to be aware of with this is that these mortgages were obtained by giving false information on mortgage applications. But at the end of the day, The mortgages were very fully secured on the properties that had been purchased. The mortgage repayments were made scrupulously on time. The lenders lost not a penny as a result of the fraudulent applications. And indeed, when the lenders were alerted by the police to the fact that the mortgage applications had been dishonestly made and were fraudulent, the lenders said, well, so what? We don't really care. And they didn't complain. Nevertheless, Mr. Zuman and Mr. Khan were prosecuted. They had built up property portfolios over a period of decades, in fact, large property portfolios based on fraudulently obtained mortgages. And they were convicted of the frauds, and the matter went to confiscation. Now, sadly, prior to the confiscation hearings, Mr. Zuman and Mr. Khan dismissed their legal representatives, and they conducted the confiscation cases themselves in person, notwithstanding that they had some language difficulties and they needed interpreters and so on and so on. And basically what they said at the confiscation proceedings was this: the lenders have lost nothing. We shouldn't have been convicted. This is everybody on the prosecution side of the judge. They have all been corrupt, and they have sentenced us to this, and it never should have happened. They also gave a little bit of information to show that they had purchased the properties and what the rents had been. As you can perhaps imagine, the Crown Court judge who dealt with the confiscation was not impressed at being told that he was corrupt. He was not impressed at being told that the confiscations, that the convictions should not have happened, and the proceedings should not have been brought, and it was all corrupt. And he said, well, this is irrelevant. What you're trying to do is you're trying to rehash the trial. You've been convicted. Now please deal with the confiscation. And Mr. Zuman and Mr. Khan said, well, we don't know how to, but it's all corrupt and it shouldn't be happening. As you might expect, that was an unmitigated disaster as far as the confiscation case was concerned, because the judge accepted every dot and comma of what the prosecution had said, except that where the prosecution had pointed to their known assets, the judge decided that he would simply make orders that they pay the amounts of benefit, which were very much higher than their known assets. And what he said was, I haven't heard any evidence to show me that the benefit is less than the known assets. So he made orders, I think, of about 8 million and about 4 million against Mr. Zuman and Mr. Khan. Eventually, they got legal representation and an appeal was made. In fact, more than one appeal was made, and that caused additional complications. But the Court of Appeal did finally say that this should go back to the Crown Court and be heard again, because one of the reasons was that in arriving at an order that the benefit was the amount to pay and that there should be no consideration of the available amount, the judge had in fact overlooked information about what assets there were. And there was in fact no information to suggest that any further assets had been found that Mr. Zuman and Mr. Khan had not admitted to. So the Court of Appeal, with a certain amount of reluctance, I think, and with a lot of sympathy for the judge, decided to send it back to the Crown Court for a reconsideration in front of a new judge. One of the things that they said here was they distinguished between expert evidence and information. And they did talk in this rather long judgment about confiscation involving the presentation of a statement of information rather than simply expert evidence. So it's an interesting one from that point of view. And if ever you want to read about how disastrously wrong things can go when defendants act for themselves in person in confiscation cases, then do read Zuman and Khan. Finally, I want to mention the case of Andrews. This concerned a person who obtained employment with submission of false CV. And what was interesting about this case was that the court confirmed two things. One, that the defendant had obtained remuneration, which was a benefit obtained as a result of or in connection with his particular criminal conduct. So the remuneration was a benefit. But then they went on to say that the defendant in this case had properly performed his duties, that the roles that he was appointed to did not actually specifically require particular memberships of professional bodies or anything like that, that he hadn't actually got. They were general management jobs, and that he had properly performed his duties. And the court said he had given full value for the remuneration which he had obtained. So on grounds of proportionality, the confiscation order was quashed. Comes as a bit of a shock that perhaps that somebody can submit a false CV, get a job, earn lots of money, and not be subject to confiscation. But as I say, the logic was that the defendant had given full value for money in the work that he did. Right, so how can we help? Well, Bartfield's Forensic Accountants remains fully staffed. We undertake legal aided, privately funded criminal work and civil forensic accountancy work. It is relatively easy, fortunately, for us to conduct the bulk of our work remotely using our up-to-date and secure IT facilities, and we remain readily contactable by phone, email, and online video links. Our recently updated website is full of useful information, and of course that is accessible 24/7. You can find more on this topic in our Insights section in the news area. And this particular webinar and future webinars will be available in our seminars section of the website. You'll be able to see a recording of them there. We will in any case send you a free recording of this webinar. And if you've got questions, do please email me. The email is best. The email address is there on the screen. I'm not usually in the office very much, so better to email me rather than phone. Thank you very much for your time. I've gone slightly over my 30 minutes. I hope you'll forgive me, and I'll see you again very soon. Thank you. Goodbye.